in sanctions work if I thought that was going to be the outcome. I just want to say, having listened to Simon Weston's amazing speech just now, the day he was blown up, I think, was the day I did my final A level, and I was just contemplating the summer of fun I had afterwards and the amazing journey he went through and started on that day. And it was just very inspiring listening to that, and yeah, made me think a lot. When I did my A levels, I did a degree in Russian history, and one of my special subjects was Catherine the Great and the expansion of Russia down into Ukraine. And I spent a lot of time examining that and all sorts, and then moved into accountancy and forgot all about these things until in 2022 we saw Russia expand into Ukraine once again, and it brought back a lot of memories. What I didn't realise at that time, it was also going to produce a lot of work for me and things going forward. As we'll all remember, the sort of immediate impact, we saw Russian companies and Russian individuals in particular become subject to sanctions. There was a very large British company called Cargo Logic Air, which was owned ultimately by a Russian, but was a large employer in the UK. There was about 150, 200 people. It was the largest single-deck cargo plane group. It had done a lot of humanitarian work, but it was ultimately owned by a Russian guy called Alexei Shakin. Now, he was one of the first to be sanctioned, which is interesting. So he was obviously very close to the powers that be. The airline had to stop flying. It was immediately subject to EU and American sanctions. Its planes were taken away, and the directors in the UK, Shakin resigned as director, appointed another Russian director with a very wet-ink contract, which I may talk about later. And the banks froze everything that the company had. It couldn't go forward, and it was subject to sanctions, and was desperately trying to find a way to go forward because there are a lot of British people and jobs and money at stake. Eventually, they became subject to sanctions themselves, because if the company is sanctioned, then if the ultimate owner is sanctioned, then the company faces the same fate. So my partner David Buchler and I became involved. It was a new area for us, and obviously for a lot of people in the legal world. We've been through a massive learning curve in relation to dealing with sanctioned entities. We chose to do the matter as an administration, and taking legal advice, we were also very aware of the steps we needed to take so that we, in Alex's word, didn't have to go to prison. A lot of legal advice was taken, and we made the application for an administration. And I was given one word of advice by someone who isn't in this room, but another insolvency practitioner. He said, get your bank accounts sorted out very, very quickly. Get something in the order to allow you to use a bank account. And I think that was our biggest takeaway from that whole situation, that we're going to need to put the money somewhere. Now, there was about $15 million sitting in a bank account. We thought, yeah, that's a nice amount. Surely a bank's going to be willing to work with us and the OFSI regime and take the money. No. We had an absolute nightmare. And I've got to do a special call out to Justin Dion and his team, because they were absolutely amazing. And we were able to use, and still use, the insolvency services account in order to actually deal with the cash. It's been problematic for the practice as well as the case, because we had situations where our then bankers didn't even like us being paid using assets from a sanctioned company, notwithstanding OFSI license, creditor approval, and the money coming through the ISA account. It caused a lot of issues, and I think it's something that you need to be aware of when taking these cases, that despite having a sort of full legal background, which Alex will come on, and ticking all the right boxes on the right checklists, if the bank says no, the bank says no. Now, I would have stopped that part of the talk now, but I had a conversation with a bank last night, and I think things have improved, a shout out to the guys at Barclays I was talking to. They've learned what sanctions are, and their legal people are more amenable to allowing these bank accounts to be held. But it was a major problem for our practice, and I think it's indicative of how things have developed in the legal world more recently, that the banks are willing to look at it and work alongside, and this Russian beast isn't quite as scary. Okay. Now, that's cargo logic. I don't know whether we had thought that Alex would come in with some technical things.
I won't bore you, but let's give some structure to this case study. So what are sanctions? You've got trade sanctions and financial sanctions. The trade sanctions are sort of sanctions that hit a certain commodity. So for example, if you have an administration insolvency where you're trying to sell a car or you're trying to sell jewellery, for example, but they are sanctioned under trade sanctions, you can't do it without getting a licence. And then you have financial sanctions. So you've got the situation of perhaps an oligarch where an individual and their connected entities cannot be dealt with. So there's two kind of species of sanctions. Again, if you get it wrong, the maximum penalty is a 7-year prison sentence, £1 million fine, or 50% of the transaction that you are dealing with, whichever is higher. So it helps kind of focus your mind a bit more on why this is important. It's okay, actually, to work through this in a very methodical manner. One, obviously, prevention is better than a cure. So with you guys, having procedures in place, making sure you've got your checklists right. How do you deal with sanctions? How have you ring-fenced it? Have you applied to OFSI, which is the Government Agency Department of Treasury, for a licence for permission to actually deal in those assets? What happens practically, as Joe's just described, is effectively the money which you secure for benefits of creditors, ultimately gets popped into a dedicated bank account, which is controlled generally by the Insolvency Service. In your case, yeah, exactly. Yeah, we'll see where that goes. For the benefit of creditors ultimately. Look, I'm a lawyer, so I'm going to say get the lawyers involved pretty quickly. For a number of reasons. One, you've got to understand as IPs what the risk looks like, and lawyers are pretty good actually getting underneath corporate structures and finding out actually who's the ultimate beneficial owner, who has an interest in this business, and how do the sanctions touch that business. Two, lawyers and the advice that surrounds it generally is protected by privilege, and therefore you have some protection about how you manoeuvre, how you plan ahead. That's really important for you, yes, so you can do it in a safe environment. Three, lawyers are insured. So if a lawyer is advising you that actually the step you're taking is reasonable, that's a good way to be able to sleep at night going forwards. So have that structure in place. When you're applying to OFSI, get a lawyer to help and actually get the licence. Go wide with your application. Be careful about how the licence will be fairly narrow in its prescription as to what you can and cannot do, and just document everything that you're doing. And then it's fairly straightforward going forward on that.
Yeah, I would add that. I mean, the OFSI licence application procedure was extremely detailed, and it was useful to actually be able to think about everything you're going to want to do. So it was going back to fundamentals of an administration, the ability to deal with employees, the ability to settle claims, deal with things, look at contracts. We put everything into the OFSI licence that we could think of, and it did work. As I said, the details of the bank account were very important. I have another case where we were appointed as administrators of a company that had a Russian investor. She was the daughter of an oligarch, and she hadn't been sanctioned. He hadn't been sanctioned. And it was about a year and a half after the invasion. She was suddenly sanctioned, and this particular company was just coming up to either round 2 or round 3 of its investment. It did something on apps that I never fully understood, but it was quite valuable and pretty useful. They suddenly found all their investment rounds were being pulled. They couldn't get any cash, and the burn was significant. The Russian lady didn't like the fact that it happened, but she had other investments, and they were having a similar impact on all of them. The only solution we could see on that particular case was to pre-pack the business and remove the Russian problem. We were then left with the problem of the vast majority of the assets, because the business had been pre-packed and had been fairly solvent until that point, were going to be paid to the Russian lady. So again, it was back to OFSI and the Treasury and guidance as to could she be paid. She had a pretty good legal team who were actually very useful at getting consent from OFSI for people to make payments to them and accept. So we let them make the OFSI application. But what you have to factor in on these cases is just the sheer period of time it can be to get the license in place. She eventually got it and we were able to make the distribution. But we were always conscious that the situation can change in these cases very quickly and almost overnight. A final case I'll talk about was a relatively small NVL. It was a Russian-owned business. If you think back to all your AML training, we see the sort of standard things. Can I provide services to a business that's Russian-owned in the UK? And there's various bits you can tick to say, yes, I can do this. We checked the business out. There were no sanctions links. And part of the procedure that we have in place is to do constant sanctions checking. We put the company into NVL, and a week later, the ultimate parent was sanctioned by the systems. We picked that up very quickly because we have in place that requirement to check. And I know that the systems have developed very well over the years, but initially it was very slow and it was a mechanical check. We picked that up very, very quickly, which was useful. We were able to then put into place everything we needed to be able to continue with that case. About 3 weeks later, I got a letter from my regulator saying that they'd been informed by someone anonymous that we were dealing with a Russian company and what did I have to say about it. And having those checklists in place shows the value of planning and understanding the regime and, as Alex has said, keeping out of jail.
Quite exactly. I mean, why is it relevant for you? As IPs, as of May of this year, you have positive obligations now to check sanctions checklists, to report annually when there are issues relating to businesses that you've got conduct of, which are sanctioned, and you have to report in November for the preceding September year. So there's a lot more enhanced obligations, I'm afraid, red tape on you, but actually, as you say, checklists, making sure that the prevention of the cure, you've got the everything documented going forward, and get the lawyers involved pretty early. I think all good tips.
Yeah, I think that's where we would say it's a lot of planning, it's a lot of work and understanding, but I don't think we should be afraid of doing this particular line of work. There are a lot of businesses, if you think back, that were in the UK that had Russian links, and we also have programs like McMafia on TV to see the links, and there's more and more, but awareness as to what we can do. And this is something I think with a smaller practice, we can take the direct legal action. When we're only 2 or 3 partners, we can actually discuss it directly with them ourselves. We don't need to go to big committees to explain why we want to take this job and look at the risk. We can establish more quickly and easily within a smaller practice what the risks are and what we're prepared to do. And I think it is a bonus being a smaller boutique practice that we can actually do that going forward.
Yeah, that's a good point. I mean, think of it a bit like a process of crime, like a POCA issue. We've all had to deal with that for many, many years. Sanctions is just effectively one step sideways from that. So POCA could overlap actually with a sanctions issue, or not necessarily. So just have that back in mind. When you've got your regime in place for dealing with process of crime act issues, there's no good reason why you can't deal with sanctions as well. Just get the legal advice involved. That's all at early stage.
I think that's the big takeaway. Use the lawyers. There are specialist teams in a lot of the practices. We know most of them. We have Alex, and take legal advice and follow it, and follow your checklist so that you're not going to put yourself in a position where you can't answer that letter from the institute when they ask you what you're up to.
Great, it's our time.
I think we're
Perfect.
minus 4 seconds.
Yeah, exactly.
So
Yeah.
thank you very
Thank you.
much.
Thank you, Alex and Joe. It's just like one of several examples of some fantastic work that the small